Welcome to the Dubio podcast. The following is a conversation with Johann Soufi. Johann is a French-Algerian lawyer specializing in international criminal law and with vast experience dealing with war crimes, crimes against humanity, and human rights violations. He has worked with various international tribunals, including the Special Court for Sierra Leone, the ICTR, the ICC, and the Special Tribunal for Lebanon. Furthermore, from 2020 to March 2023, he served as head of the legal office of UNRWA in Gaza, Palestine. Johann has also directed and participated in international criminal investigations across Rwanda, East Timor, Lebanon, Ivory Coast, Mali, and Ukraine, to mention a few. And from 2024 onwards, he has led the UN Office of the High Commissioner for Human Rights Project on Sri Lanka's accountability. The conversation was very fun, so hope you enjoy.
Thanks, Johan, for joining us. It's a pleasure.
Thank you for having me, Luis.
So, start right away. I'm interested to know what motivates you to choose to specialize in international criminal law and transitional justice. And was being Franco-Algerian a factor that influenced this decision, or no?
Well, I guess being of a mixed culture and growing up in Paris suburbs also, where you have a lot of diversity, I've always been interested, in thinking beyond one lens and seeing the world and international and justice and law through different lenses. So I guess yes, in a certain extent that play a role. I believed also I was always interesting between diplomacy, politics on one hand, and law on the other hand. I always found that there were there were two areas of interest, and so international criminal law was the best area because it was in between both these fields, and every day you see how the politics influences the law and how the law has a direct impact on politics. So yeah, that's probably my answer.
Yeah, and the more so criminal law, international criminal law.
Yeah, it's also that I was always interested in national domestic criminal law. I like to understand the stories and the human being, the criminal acts. So I started in defense, both at the national and international level, but I was also interested in understanding the kind of social, historical aspect behind these mice crimes. So that's why also, yeah, I believe that it was international criminal law that was. Really
so before you specialized in international criminal law, you did a few years as a lawyer, as a criminal defense lawyer in France?
Yeah, like I work, let's say, between 2006 and 2009 at the domestic level, but already as soon as 2007, I was already part of a defense team that was representing Calix Kalemanzira, a former senior official in the Ministry of Interior in the Rwandan government during the Rwandan genocide. So I had almost these two careers for a while in parallel. I was traveling a lot to Africa and to Arusha in particular to conduct investigation and represent this individual before the ICTR, the international.
But how did you end up? How did you manage to get the experience in the ICTR? What did you do to?
Well, so I just finished. And in parallel, I was also doing what we call public defender work in France. So having these two cases. Now to answer your question, how I got this first job. Well, I finished my practice and my training as a French lawyer, and I was working in a criminal law firm in Pontoise in Paris suburbs. But then I had this aspiration to do international work. So what I did is very simple. I sent a letter to all, or at least a good portion of all the counsel who were registered as counsel at the ICC, on the ICC Defense Council list. And I think at that time, I think today we are more than 800. At the time, you were probably 100 people. So I targeted all those in France, in Europe, etc. And only one answered to me, Arthur Verken, a lawyer, was at the Paris bar at that time. And he said, look, I don't have a case at the ICC, but I have a case at the ICTR. And I'm actually just looking for someone to join my team and conduct investigations for Mr. Kalimenzira. So that's how I ended up joining his team and assisting him in representing Mr. Kalimenzira before the International Criminal Tribunal for Rwanda.
That's amazing. That's amazing. That's a great way to the persistent way of sending a letter to every council and the ICT list. Yeah. And how was the experience in the ICTR? Like, what did you do specifically? Do you conduct investigations, but with what purpose? And before, could you explain a bit about the ICTR?
Yeah, sure. So the ICTR is the International Criminal Tribunal for Rwanda, which has been established by the Security Council to try those who were allegedly involved in serious international crimes, including genocide, in Rwanda in 1994. So it has been established in 1994. I joined in 2007. And for the people who watch your podcast, especially those from a civil law background, they have to understand that these international courts apply a procedural system which is closer to common law. So to what they could see in American movies, right? Where the prosecution and the defense both conduct investigation, and the prosecution brings incriminatory evidence while the defense try to find for exculpatory evidence. So when I joined this team, my role were twofold. The first one is indeed to assist as, a lawyer, a legal officer, drafting motions, etc. But a big part of the role was also just to travel to, as I say, Africa, and especially places where there were Rwandan refugees, Congo, Kenya, Uganda, Tanzania, you name it, to find witnesses who could testify about the acts and conduct of the accused, of Mr. Kalimenzira. So that's what I did. And yeah, it was a blow, for me, it was a blow-minding experience because I was just being qualified as a French lawyer. And suddenly, I'm traveling in refugee camps in Rwanda. Also, I went a lot to Rwanda for the first time, and just trying to now do a criminal investigation to find evidence. It was amazing.
But coming from a civil law background, what were the main challenges, seeing that the procedure is much different?
Yeah, very different. Well, one of the challenges was to learn this difference and to learn that actually, to change your mind and to understand that there will be no investigative judge, trying to find the truth, and that actually you had a case to defend, and for that case you have to find evidence. So that was with not a lot of knowledge about the historical context, but also the cultural context. And I think that's, in all my career after that, what I've learned, that really a good international criminal lawyer is two things. One, the technical aspect, that's important. You need to know the mode of liability, which are very different. You need to know the substantive law, which is very different also from my national practice, but also the cultural context. Because I'll give you an example, in Rwanda, if you come, you're the lawyer, people have a tendency to agree with you. So if you ask a question in the wrong way, they'll say yes, even if that's not the truth. And it's because they want to please you. And they say, well, if he asked me this question that way, probably what he says is the truth. So at the beginning, when I had no cultural awareness about these different aspects, it would create, some strange situation in which I was in. But you have to be very modest about that, about the culture, and always start over from scratch. When you enter in a new case, you have to know that you know nothing and that you will have to learn from the beginning.
And after you were a part of the defense team, you went on to become also a legal officer for a judge, right?
Yes, correct. So that's also something which is very different in the international practice. And and my career shows that to a certain extent, is, I think in France, I don't know, it is in Portugal. In France, when you're a defense lawyer, you usually do your entire career as a defense lawyer. Sometimes you represent victims, but you're a lawyer. When you're a prosecutor, you're a prosecutor. When you're a judge, you're a judge. And in the international field, you've seen my career. I've worked for the defense. I've worked for prosecution. I've worked for judges. And indeed, in 2009, so at the end of my trial, I was recruited by the chambers of the ICTR to assist as a legal officer. And then actually I ended up working for the president, Rashida Khalid Khan, who was at that time the president of the ICTR. She was from Pakistan.
Okay. And first of all, the first question is, doesn't that make you, for example, you were on the defense team before, then you go to the judge part. Isn't there a potential conflict of interest?
Yeah, there could, definitely. I think, that was something that was raised when I was recruited. And to be honest, that's also, I ended up, I was supposed to work for a Francophone judge in a case where actually she didn't feel comfortable working with someone from the defense. And so that's how also I ended up with this judge who was the president, who was Anglophone. But yeah, there are potential conflict of interest, but I did not work in a case where there was any form of connection with my past case as a defense lawyer. So when I assisted her in the trial judgment of the government, it was 4 ministers who had nothing to do with the case of my client. And I believe, it's very important. What's important is also perception. So we have to be aware in these cases that I don't want to be perceived as biased, but it happened again in my life where I went from basically representing someone in defense and then later working on the other side.
And talking about perception, there are a lot of critics of the ICTR for the way that, for example, the perception, the national perception in Rwanda, and the question of political, almost like a political adversaries that choose to prosecute certain parties and not the other ones. What would you feel about?
Well, I think that's an interesting and very difficult question, because international criminal law in itself is selective. And, this selectivity will always create frustration. And I had that frustration, and I still believe until today that the ICTR did only half of the job. It was really good in prosecuting and trying and convicting people involved in the genocide. It did not do anything on trying, member of the RPF, so FPR in French, who also committed international crimes. And that led to a massive frustration, especially among the diaspora, the Rwandan diaspora that has fled this crime after 1994. And to a certain extent, we still see the consequences of this impunity, in DRC until today. So that's something that is extremely challenging. I believe that my way, and I've seen that all over my career now and all over my life, with the question, why this and not this? The way I've tried to be at ease to a certain extent with that feeling was also that thinking that at least a drop of justice is better than no justice at all. So there was no doubt that those who were involved in the genocide needed to be tried and prosecuted. Now, it would have been better, and it needs to be better, to also try the other, but I don't think one negates the other.
Of course. And you also, afterwards, you also participated in the special court for Sierra Leone. Could you tell me about the court itself, why it was created, with what goal? and your role?
Yes. So the ICTR was created by the Security Council at the request of the Security Council. The special court for Sierra Leone was very different. It was an hybrid court at the request of the government of Sierra Leone to try those involved in the crimes that happened there during the civil war on all parties. So that was very different in the setting. In the applicable law, you apply both international and Sierra Leone law. It was an interesting experience. I was also called because I was working on probably the flagship case of that, at least the most notorious case of that court. The case of former president of Liberia, Charles Taylor. If you have seen The Lord of War, for example, with Nicolas Cage, that's basically what it was. And I received a call, and they needed experience in, drafting high-profile cases. And as I said, I've worked at the ICTR in the judgment of the former members of the government. So that was a valuable skills, but they had to finish very quickly because they already issued a press release saying that the judgment would come very quickly. And actually, a lot of the people resigned. So when they told me, well, can you come, but you have to resign from your prior post, I say, you know what, it's a new experience. It's going to be great. Even if it's for a few months, let's go. And eventually it lasted much longer. But it was a very challenging and novel case for me also, because Charles Taylor had never put a step in Sierra Leone. So he was the president of Liberia, and he was accused of aiding and abetting or even planning crimes in Sierra Leone, but he has never been in Sierra Leone. So even from a legal and political perspective, it was an extremely interesting case because it was showing, to what extent a state or a government or an individual that aid and abet crimes while knowing that crimes will happen, and so, for example, provide weapons, political support, financial support, can also have one day to answer to justice. And it's a very interesting message, especially in the current context.
And but was the president, former president of Liberia, in Sierra Leone, or
no? He has never been in Sierra Leone. Okay, never was.
So special court in absence.
No, he was. So the court was in Sierra Leone, but Charles Taylor was eventually arrested. Okay. So he was arrested, detained, and sent to The Hague in the Netherlands, where he was tried, and he was convicted to 50 years, both in first instance and in appeal, for his participation in aiding and abetting the crimes there.
Okay. Okay, very interesting, very interesting. Do you think because Sierra Leone is a French-speaking country?
No, it's Anglophone.
Anglophone, really?
Yeah.
Okay. I thought that it was Francophone. Okay, no. Okay. But Rwanda
is used to be Francophone. Now they are both Francophone and Anglophone, because the Tutsi community coming from Uganda has more developed the English, and now because they are at power, they really developed also this the language English. And I think it's also comes with the past with Belgium and the French, so the trouble and complex past.
Exactly. Most African countries that were previously colonized, they almost start throwing everything from the French away and reading themselves of that history. So after, you also have conducted investigations in Timor-Leste, Rwanda, Ivory Coast, Central Africa Republic, and Mali. What were the biggest challenges in gathering evidence in potential conflict zones? And
well, you have different, really every theater of investigation, every scene present different challenges. I'll give you a few. The first one could be, the access. So, for example, I've worked on cases, and I'm currently, working, for example, on Sri Lanka, where we don't have access to the country. It was the same for other cases I've done in the past, where you cannot even go in the country because they don't accept you. So it means that you have to do remote investigation. That was, for example, the problem also at the Special Tribunal for Lebanon. We'll talk about that later, where the prosecution, had access to Lebanon, but knew that it was extremely challenging, because when you meet a witness, some powerful people in the country could have interest and even threaten the people you meet. So that's one of the challenge. Other challenges are just access, but because of geographical or development consideration. So for example, in Mali, when you have to go to the north, you have a lot of danger there. You have zone with mines, etc. Or in Timor-Leste, where, it's a very, you have a lot of mountain, a lot of jungle. So sometimes to identify the victims or the witnesses and meet them, that's extremely challenging. I would say the last one perhaps is also to find the right, first to find the evidence, because you need to, sometimes people just don't know who did what. They know that a crime took place, they just don't know who is behind the crime. And for that, you need insiders, what we call insiders, which are people who are aligned with the perpetrators. And most of the time, they don't have an interest to talk, because they are also accomplices to a certain extent of the crimes. And even if they have an interest to talk, they're going to fear reprisal against them. So that's where I think it's extremely challenging to investigate these crimes. Just for the people who listen, perhaps they can think about a mafia case, Just imagine you're doing a case against the mafia in a country where the mafia is very powerful. You understand how difficult that is? Well, that's basically what you have to do with most of the international criminal cases.
But while conducting, gathering evidence, people and you search more for testimonies. But nowadays, do you search for more like online evidence rather than the testimonies and so on?
Yeah, well, it also depends, and I'm sorry, I always say it depends, but it also depends really of the country. So and of the time, So for example, because the ICTR, the Rwanda, was a common law trial, and because the crime took place in 1994, you need witnesses. You need to say what they have seen. You will not have any digital evidence of the crime, etc. Now, if you do, for example, if you take the case of the Tribunal for Lebanon, there was no eyewitness. I mean, you have eyewitness of the explosion, but nobody knew who did that. And so the prosecution had to rely only on circumstantial evidence, on what we call cold data records. So like basically the phones and the digital evidence. Now, if you take, for example, the crimes committed by Israel in Gaza, most of the soldiers, they film even their crimes and they upload them on TikTok. So a big part of the evidence is going to be also this digital evidence to show their responsibility. So it really depends of the time of the crime, but also of the technology development of the place where you investigate.
And also the procedural rules of the court, right? If the court accepts open source evidence or no.
Exactly, because, so for example, in common law, you need also to have the ability of, one, knowing the source of the evidence and the chain of custody, to be sure, for example, that, with AI, now you can create a lot of, fake videos, but also with hearsay, you can have someone who say, yeah, I saw that. And so you have also the right for the defense and the protection to cross-examine that evidence. So that means that the person who issue a statement or documents need to come to court, so that you have the ability of challenging the credibility and the reliability of that evidence. So yeah, indeed, most of the time, you need to corroborate the documents, the hard evidence in a way, with a statement from someone who has issued that evidence, that document, or who can testify about his authenticity.
And so I think it's perfect to go to now talk about the Special Tribunal for Lebanon. As you previously, for reference, my last guest was David Young, Barrister in International Defense Council, who acted on behalf of Assad Sabra in the STL, as you know, the only accused that was acquitted. And I wanted you to please explain what was the Special Tribunal for Lebanon, like the context of its creation, if you may.
Yes, so on 14 February 2005, so 20 years today, the former Prime Minister Rafik Hariri was killed in an explosion, in a big explosion that shaken Lebanon to its roots. Now, the attacks was claimed by Al-Qaeda, but there was suspicion that either Syria or Hezbollah could be behind the attacks, and some Lebanese were claiming for, or were asking for, an international court to investigate the matter because they believed, and probably rightly so, that the judicial system in Lebanon would not have the means and the sufficient independence to conduct this investigation. So first there was a commission of inquiry, of a UN commission of inquiry, who conducted the investigation and later recommended for the creation and the establishment of an international or hybrid court. So the STL was a very specific court because it had Lebanese feature. It was applying Lebanese law. It had also the possibility of trying people in absentia, which means without the accused being present. But it was also composed of international lawyers, international judges, and prosecutors. Now, one of the characteristics, the other characteristic of the STL was that because of this in absentia trial, they tried really to reinforce the defense part. Remember, I said at the beginning that in common law, the equality of arms is a very cornerstone of the criminal process. But when you have a trial in absentia, you don't have an accused. So in order to balance this equality of arm, they established an independent defense office. And I was part of this defense office, first as a legal advisor, and then that the chief of the legal advisory section. And our role was to ensure that defense rights in general, not the right of Mr. Sabra, of Mr. Ayash, or Mr. Badreddin, but the right of the accused in general within the institution were preserved. And so that's why we're going in court every day. We're also making submissions on behalf of the accused with a big A and not specific individuals.
But what specifically, what were the rights that you were trying to preserve and guarantee that the accused had?
Well, one example could be, for example, one of the accused, Badreddin, died during the trial. And that was a strange thing because the trial chamber at the time was not convinced he was dead. He was killed in Syria. Nobody knows by whom. And Hezbollah issued a statement saying Badreddin is dead. An Iranian delegation, Syrian delegation came to say, to mourn the dead person, etc. So that was the evidence that he was dead. On the other hand, before other courts where you have the accused in custody, you know when they are dead. It's, you have a dead body. There was no dead body there. And so the trial chamber didn't want to stop the proceedings. And you can understand why also defense counsel were a bit torn. If the case is over, then the case is over. It means they're also unemployed. And it means that, they cannot also represent all the good argument that they had, that they wanted to raise in court. It's over because there is no more trial. So the trial chamber at the time ordered the defense counsel to continue to represent the accused. And the lead counsel say, no, I cannot do that. I know he's dead. I believe it strongly. And so my ethics, my code of ethics, he was French, Lebanese. He say, my code of ethics prevent me from representing that individual because he's dead. The two other counsel were from a common law system and said, well, you know what? We are officer of the court. The court ordered us to continue to represent that person. It's our moral and ethical duty to do so. And so that's where you see where a defense office, which works almost like a, you know, like ethical body also, that's where we had also to find a solution and to also issue some guidance to see what could be the right of the accused, not only of Mr. Badreddin, but more generally of the accused in such context.
And this court, also another very interesting characteristic was the prosecution of the crime of terrorism. As a result of the killing of Rafik Hariri. It's interesting that the title of your thesis was the universal definition of terrorism, and even though it was written 20 years ago, it still makes very pertinent points still being used today. For example, you said that everybody can be considered a terrorist at a certain point of time, and what I wanted to talk specifically was the definition of terrorism and freedom fighters. And now can the international community reach an agreement on what can be considered freedom fighters and what is considered terrorism? We see that now that, because even with my former guest, Namira Negam, one point that she made was, while talking about Gaza and Palestine, that Hamas nonetheless is considered a freedom fighter under international law because it has occupied territory, and at the same time as being occupied, they are considered freedom fighters, and they have to abide by the rule of law, the rule of international law, 100%. But they have to be considered freedom fighters. What is your perspective on this?
Yeah, I've always been, so I wrote my thesis of master on the definition of terrorism in 2004. So it was just after the World Trade Center terrorist attack. And there was a lot of debate at that time and willingness to come with a universal definition of terrorism, because the best way to fight a crime is first to define it. Otherwise, it can be also politically instrumentalized, as you said. And one of the specificity of the crime that the SCL was mandated to try and prosecute was that, it was not a war crime. There was no armed conflict. It was not a crime against humanity because it was not part of a generalized or systematic attack against the civilian population. And it was not genocide. So the core crimes of the ICC or all the international courts did not apply to that case. So they came up with the idea of a court to try the crime of terrorism. The problem is why to have an international court that with no definition. That was one of the challenge. And indeed, the issue of 20 years ago is still very relevant today. And what are the two key issues for the definition of terrorism? Is number one, can a state, because we all kind of agree on what terrorism is the fact to impose terror in order to achieve a political goal. So that's, everybody kind of agree on these key principles. Now the problem is two things. One, the fact that a state used terror in order to achieve also political goals, is that the crime of terrorism or not? And the second one is a group that used terror for legitimate purpose, for example, freedom, is it considered as terrorism? The issue is that states still do not agree on that, on these two particular aspects. And I think that, to be a bit schematic, the division is between two blocks. The state that experienced oppression and colonialism and said, you know what, when there is asymmetry, there is no other choice. And so for us, we want state to be also liable for terrorism, and an exception when we fight for freedom that this does not constitute terrorism. Other states consider that this should not apply. And that's why until today, we don't have a definition. So I don't want to escape your question now about Gaza or anything. I do not believe that terrorism is a useful legal notion. I believe that war crimes or crimes against humanity already provide for the legal framework to, qualify what is happening in the world right now at the international level. I'll give you an example and I'll answer your question. Do the Palestinians have a right to freedom, including by resisting through armed means? The answer is yes. Do Palestinians have the right to kill civilians or people who do not take part in the hostilities? The answer is no. So in one way, yeah, you have a right to resistance, 100%. Do you have the right to kill civilians? No, these constitute war crimes or crimes against humanity. And that applies for Ukrainian, that applies for Congolese, that applies for all the people of the world. I think that provide a much better and more equal legal framework.
Yeah, exactly. Instead of having a certain type of group be considered terrorist for defending or for armed resistance, and the others no.
Yeah, I think that's also, if I can, that's the beauty of the law. One of the challenge, and perhaps we'll talk about that after, but that I faced when I was going in French media, is there was so much focus on who did what. Yes, but it's Hamas, it's a terrorist group. Yes, but it's Russia, it's a rogue state. Yeah, but it's Israel, it's a democracy. And all these things for the international lawyer that we are is irrelevant. What counts is the act that you commit, whether you're a democracy, whether you're a freedom fighter, whether you're a terrorist group, that does not matter. We try and we prosecute and we investigate acts that are contrary to international humanitarian law. That is as simple as that.
Yeah, it's a broader justice. Sense of justice is not specific who is who, but who commits the specific crime and how it has to be.
Yeah, because the terrorist, as you correctly say, the terrorist of one is always the hero of another. Nelson Mandela was a terrorist, Fidel Castro, and some people consider that George Bush or even Barack Obama, who has a Nobel Prize, is a terrorist. So that's why this notion, I think, is not really useful for lawyers.
And going a bit back to the STL, do you believe that the Lebanese people, after the special court ended, were satisfied with the justice that was made, or no?
No, I think that shows this tribunal was a failure. Let me put it very bluntly, for many reasons. I think one of the reasons was not to understand the specific nature of trial in absentia, and to try to do a case as if it was a normal trial. I can tell you from a defense perspective, this is not a normal trial. You receive no instruction from your client. So you don't even have a case theory. You cannot raise an alibi. So you cannot have a real defense. And that requires then to obstruct everything the prosecution say. So it's very time consuming, and it's a lot of use of resources for something that ends up unsatisfactory for everyone, including for the victims, because the accused has a right to be retried de novo if they are arrested. So it questions also the purpose of that system. The second one was also, I've talked about cultural awareness. I really do believe that although the defense has tried to be much closer to the Lebanese culture and the Lebanese people, I do believe that some people at the SCL were stuck in their cultural bias and legal culture, and try to replicate what they have learned at the ICTY, the Court for Ex-Yugoslavia, or in their domestic system in France, in the UK, in Canada, in Australia, in the US, and to tell the Lebanese, well, that's what justice looks like. That's what is a good trial. And that does not work. That will never work. Justice is first and foremost for the affected communities. And so what is the result is that after years of trial, after almost $1 billion of trial, we ended up with a trial that has satisfied no one. Is Lebanon today better than it was 20 years ago? The answer is no. As it's not the fault of the STL only, but as the STL contribute to something meaningful for the Lebanese, I think it did not. And I think it's also important for all the people who work at the STL, including myself, to also question our own contribution in this failure.
Yeah, it's considered one of the most expensive special courts, the 1 billion court almost. So
yeah, but if I can say something on that also, that's where it shows, the link between politics and the law. Why did states put so much money in an in absentia trial against five alleged Hezbollah members? Why don't they put so much money in the special court for Central African Republic right now? Well, the answer is very obvious. It's politics. And so, I used to laugh with my friend at the ICC. I said, if you want the money, just do the thing that some states consider a priority. And we see that today, right? Ukraine, case against Ukraine, the ICC is at the flagship of the fight against impunity. We need the ICC. The American narrative about the ICC was, we will support you. The head of prosecution at the ICC for the Ukrainian case is an American. Well, a few months later, when the prosecutor issued an indictment or request an arrest warrant against Israeli leaders, the narrative has flipped totally. And so now they want to destroy the ICC. So you see also why I think these resources and the shortcoming of the STL cannot also be explained without a knowledge of the political context.
Yeah, I think that's one of the biggest problems in international law and international criminal law is the political side. And certain decisions are made not to fight impunity, but in order to follow a political plan and the strategic.
But I think I think today we're like in Matrix, right? We took the red pill, and so people realize, whoa! But that has been there all along. I mean, the creation of the ICTR and ICTY was the result of a Security Council decision. This means that one state out of the 5 permanent members can just raise their hand and then block any justice initiative for these people, for the victims. Why was there an international special court for the crime against, for the assassination of Rafik Hariri, and no international court for the hundreds of thousands of victims in Syria, which is just at the same time and just next to, which has a border? And I will take just the other neighbor in the source. Why was there no international court for Palestinians who are also victims of the two neighbors of Lebanon? So you see how actually from the very inception of international criminal justice, politics played a key part. I think that we've already tried, and what the ICC is experiencing today is an attempt by the judges, the prosecutor, the Victims Council, Defense Council, to try to move away from that political area. And that's something, which is great, but that's going to be a permanent fight, I think, and struggle.
And as you mentioned before, and as we talked about Palestine, and even your master thesis, the examples that you made, you mentioned Palestine a lot, and it's been a current issue for dozens and dozens of years. And I wanted for you to address the pressing situation from the legal standpoint, and also from your former experience as investigator of international crimes, as we have seen a consistent accountability for Israelis who are committing crimes on a daily basis, crimes against humanity, war crimes, and crimes of genocide being televised to our screens, telephone screens. And as you said previously, the TikTok, the videos, it's all over the internet. You can open your Instagram and you see clips. And I wanted you to address that, if you may.
Yeah, of course. So in my career, it's less relevant for the people interested in international criminal law, but I was also from 2020 up to the end of 2022, the head of the legal office of UNRWA in Gaza. So I was very familiar with the situation and the oppression that the Palestinian people in Gaza especially were suffering before 7 October 2023. You know, the blockade had been already going on since 2007, the discrimination, the abuse, and the regular war crimes as documented by the UN in 2009, in 2014, in 2018, and so on. And I'll explain why I'm mentioning that, I've been to Ukraine, right, to also support prosecution and investigation into international crimes, including crime against humanity committed by Russia in Ukraine. And then I came back, and it was 7 October. And, you know, I've been used all my entire life to one narrative. Impunity is extremely bad for peace and security. And when there is an international crimes being committed, we need to do everything to fight impunity. That's what I believe. That's what I've been trained for. And that was my mindset. And so it was a big slap in my face where in October, in November, while seeing this crime that you are describing, and while being in touch with my friends and former colleagues in Gaza, I saw the narrative shifting. I saw all the people that were, or a lot of the people supporting me for my job over the past decades and for what I was doing in Ukraine a few months before, suddenly being uneased with my narrative, which was, or with the mere fact of saying that indeed what Israel is committing in Gaza and in Palestine in general, not only in October, but before, is a violation of international law and constitute a war crime and a crime against humanity and possibly the crime of genocide. And you know, it's funny enough that when in September, so before 7 October, I published an op-ed in Le Monde. I was coming back from Ukraine, and the ICC has been doing an extraordinary work in Ukraine. It had received a lot of financial, political, technical support from a lot of countries, including mine. And I came back and I felt, you know what, this is great. But I do believe, and that was the title of my op-ed, I do believe that the future of the ICC is in Palestine. And my theory for that was Palestine will be the litmus test of international law and of the credibility of the Western narrative on international criminal justice. If you do Palestine, it means that really your justice is blind, and you try every situation the same way. If you do not do Palestine, while it shares a lot of features with Ukraine, a big powerful state is invading another, is annexing part of its territory, is committing international crimes, war crimes, crimes against humanity, is having a narrative that the other population does not even exist. If you do not do that case, then actually it means that you do not believe in international justice. You just believe in politics, achieving politics through other means, including international law. And that will be the end of international justice, because people believe in justice only as long as it's independent and impartial. If you do not show this, that's the end of the court. I was extremely relieved, and if you see the video, over months and months, I said the ICC, despite all the pressure, will issue an arrest warrant against Benjamin Netanyahu and all the Israeli leaders, because the evidence is here, because the crimes are there, and because there is no other option. Otherwise, that's the death of the court. And so that's why I do believe that indeed, international justice has answered to the call. It has met their responsibility. Today, a big part of the Western countries, not all of them, Spain is great, Ireland is great, Belgium is great, but a lot of countries, including mine, which have very problematic statements at times, it has answered. And now, as I said, it's the red pill in Matrix. Now we see it's good. It's terrible. It's very difficult. It's painful for all the people who believe in international justice. But it was a moment that we all knew would happen one day. This moment of truth, we're here. Let's see.
It's true, but one could say that it's been too long for the arrest warrants to come, not only for Netanyahu, but the previous governments and the consistent violation of human rights in Palestine. Myself, also being of Egyptian origins, I've always known that Palestine has been occupied and Palestinian rights have been shuffled under a bed. And you, for example, have been working the UNRWA, and now the UNRWA being banned in Israel and being stopped the financing. For example, a lot of states have stopped or reduced the amounts that they fund the UNRWA. And from that side, from that perspective, now we see that without UNRWA, how can aid get into who's going to take care of all the problems in Gaza or West Bank?
I think so. There are two different questions here, and I'll address both of them. The first one is about the delays and selectivity.
Yeah,
I agree, but that's what I said at the beginning. International criminal law is inherently selective. And so, being a prosecutor of the ICC is an extremely difficult job, right? Because all the victims in the world deserve justice. And so you have to make choice. And for a long time, Palestine was not a priority of the court. That is true for political reason, but also because they made their choice. Where I think it's a bit unfair is to, take Ukraine, for example, because that's usually a good test. And people told me, you know what, in Ukraine, the Ukrainian victims got justice and not the Palestinian. When was the invasion of Crimea, and when did it start, actually? In 2014.
Yeah.
And they have been claiming justice, and nothing happened until 2022, when for political reason, they decided to shift. And also because they saw what impunity for all the crimes that took place between 2014 and 2022. So, even the people in Ukraine were saying, you did nothing. They annexed totally Crimea, and you have done nothing. And it's only now that you're doing. And then the arrest warrants against Vladimir Putin came in March 2023. So 1 year later, and only for the war crime of deportation of children, right? Okay. Now Palestine. Palestine occupation, annexation have lasted also for decades. The crimes took place also for decades. And then in 2015, Palestine joined the ICC Rome Statute. So more or less when Ukraine is also asking the ICC to intervene. And then nothing happened until 2023. So in terms of the timing, we're exactly in the same. Now, the arrest warrant came in 2024, so 1 year later, also again the head of the government, but for war crimes, crimes against humanity, including persecution, extermination. So in a sense, you know, you can see it, you can see the
Everything is
glass
moving.
half full
Yeah.
or half empty. I'm extremely happy that the prosecution, because it has the evidence also,
Yeah, of course.
went all in. But is there frustration that genocide was not also charged? Yes, especially considering the ICJ case. Am I even more frustrated that no case was done for the West Bank, where it's very easy to prove? I mean, even if you take from a prosecutorial perspective, the evidence is there. I mean, it's a war crime to transfer your population within an occupied territory. They're not even hiding it. So, of course, you could also charge an individual for crimes in the West Bank. But then, you know, people in Nigeria will say, what about us? People in the Philippines, people in Myanmar, and or in Afghanistan. Today we see these arrest warrants, but that's where I say that, you know, a drop of justice is better than no justice at all.
Yeah.
If you don't have this mindset and you do international criminal law, you're going to suffer every single day of your life. So, you know, I think there is also, perhaps to the people who listen to you, a tale that I like to remind myself. You know, there is a big fire in the forest, and all the animals, they watch and they do nothing because they cannot do anything. The fire is spreading, and then you have a little bird, a colibri, that is bringing a drop of water. And then the elephant, the zebra, the tiger, they look at him and like, what are you doing? And he's saying, I'm doing my part. I believe that as criminal lawyers, as prosecutor, as defense lawyer, as victim representative, that the only thing we can do is we can do our part.
That's very inspiring. 100%. Even if it's a small drop, yeah, it's better. It's for sure better than nothing. A drop than nothing. And regarding the UNRWA and UNRWA banning, and having worked there for 3 years, what was the experience and what do you think about the consequences of this banning?
Not only I worked there, but I hated the legal office. So, you know, that's also when these allegation came, I was, you know, rather than asking this Israeli colonel who has a clear motive to get rid of UNRWA, and I'll explain why, ask someone who is unbiased. I mean, I don't care more about UNRWA than any of the employer I've worked before. If there was a significant problem, I would also say it because it's also my duty to raise it. So UNRWA is like any organization, UN organization, is working in a complex political environment. Now, this has been established by independent investigation. This is one of the organizations that has the most rigorous process to ensure that is 30,000 staff does not bring, most of them being Palestinian refugees, are abiding by impartiality, independence, etc. So now the allegations were extremely serious, right? The fact that 9, 12, even 20 employees of UNRWA could have participated, aid and abet, or anything else. The crimes of 7 October were extremely serious. But we're still talking about 7, 9, or 12 people out of 30,000. That is not showing a default in the organization. It's showing individual liability of these people who, if they are alive, should be fired, well, first investigated, and if it's proven, fired and tried for what they have done. That is very clear. But the allegation, the Israeli allegation against UNRWA were very different. What they wanted was to dismiss the entire organization. And there are two things I need to remind people here. The first one is the occupying power has a legal duty to ensure the humanitarian assistance of the occupied population. This is in the Geneva Convention, and this is even more true that the ICJ, in their order to prevent genocide, have instructed Israeli to lift any restriction to humanitarian assistance to UNRWA, which I recall, is the main provider, is the only credible provider of humanitarian assistance in the occupied territory. What is the alternative? If it's not Israel, it's a Palestinian state. That, the day UNRWA will disappear is when it will be for the Palestinian to take care of their own population. And that was everyone aspires to, or at least everyone who has a credible agenda is like, please dismantle UNRWA. Only when you have a functioning Palestinian state that can take care of their own population. That is what the Israeli government does not want. So they do not want a Palestinian state, and they do not want an agency which has been established in 1949. Why? Because the root existence of UNRWA is linked to Nakba. And so every single day that UNRWA exists is a reminder to Israel that the fate of the Palestinian people of Gaza is to be displaced and that they have a right to return. That's the problem. I don't think Israel wants to dismantle UNRWA and so that they don't receive any humanitarian assistance anymore, for the mere reason that if not, it's going to be their legal duty. So they will be very happy with any state, any organization taking care of these people, as long as it's not an organization that was created as a result of the Nakba. So this allegation against UNRWA, although very serious, they have a political incentive, a political motivation, and it is to dismantle this organization due to this historical and political aspect.
That's a very interesting take. I haven't thought about that specific thing, but it's true. It was created after the Nakba, so in 48, the Nakba, 49, yeah. So it makes totally sense.
And I can tell you why I believe that this is true. It's because, Israel has always considered UNRWA as a necessary evil for them. Who were the main budget provider of UNRWA? The US and Germany, two very close allies to Israel. Why? Because they knew that UNRWA was doing a service that otherwise Israel would have to do. Everybody in the region understood why UNRWA was a force of stability for the region, because a population that has no hope, that is starving, will develop violence as a mean. So even for Israel to keep the Gaza Strip and the West Bank, provided with humanitarian assistance was also part of a security reason. And there are a lot of smart people in Israel who understood that, who said, what, yes, we need UNRWA. That's why also we had some cooperation and good cooperation with the Israeli military, who let the humanitarian assistance entered before, of course, with a lot of restrictions and constraints, but that was also because they understood that this was necessary for the general stability of the region, and that's what the American, the German, and the Western donors understood also.
But now that UNRWA is banned in Israel, of operating in Israel, how is it going to work? With entering, it's not.
Well, that's one of the issues, that right now this has been a very first, it's an illegal decision. Everybody understands that, against the Geneva Convention, against the ICJ order, against Israeli duties. But now the problem is that UNRWA cannot function without the cooperation with Israel as occupying power. Because if you do not have, first, you do not have access to the Gaza Strip and to the West Bank still until today. But two, if you do not have the visa, the authorization, the goods certification, etc., from the occupying power, you're just not able to function. So, well, we always come at the same conclusion. Now it's for the Western states, the Arab states, and the entire international community to abide by their word and to say, when you say that the Geneva Conventions are important, when you say that international law is important, and we see now how they freak out with what Trump is doing. And they say, no, we need to respect international law. Well, if you do believe about that, then you have to find political constraints against Israel to force them to abide by international law, including by allowing UNRWA to function and operate in occupied territories. That's as simple as that.
And now even a broader thing, that's the aid and abetting and accomplice states that are still selling arms to Israel, notwithstanding that we all know that arms are being used to murder and to commit all the crimes. Do you think in the near future those crimes are going to be prosecuted for aid and abetting, or it's
Well,
not very?
there are two difficulties. So that's why also I reminded Taylor, right? Because Charles Taylor literally aided and abetted international crimes, knowing so, provided weapons, money, etc. Now, a lot of states, especially those who are the most powerful ones, have done that, continue to do that. When you are in the business of weapon selling, most of your clients also commit crimes. It's true for Yemen, Syria, Iran, Israel, you name them. So that's a challenge. Another challenge is that international law is very weak in terms of state responsibility. Nicaragua has tried to also sue, let's say, Germany before the ICJ for aiding and abetting genocide. I don't think this will go through. And already with a state that commits international crimes, let's say Israel, at the end of the day, state responsibility is more declarative than anything else. I think there is some progress that we can do toward that. It's still a very important role of the ICJ. I think one of the other way to, continue the struggle is also to target companies, individuals. So yes, I believe that there will be more and more companies prosecuted for aiding and abetting crimes. If the company stops, if you don't have shipping companies shipping the weapons, if you don't have company, you stop it. That's as simple as that. A state cannot send weapons without shipping companies. So I think that right now a more realistic prospect is to focus our attention and our strategy on that. Because, for example, a French company, Lafarge, has been prosecuting and tried for aiding and abetting crimes against humanity in Syria.
Yeah.
That is a big deterrent effect. If every company believes that by continuing to trading with the Israeli army, they can be perhaps in 5 years, perhaps in 20 years prosecuted, and that the CEO of that company can be also prosecuted individually, believe me, they will think twice. So I think that's where, boycott, sanctions, but also activism in the field of the legal prosecution and complaints will work eventually, more than state responsibility before the ICJ or before domestic courts.
There's also one of your connationals, Omer Shatz, who is also an Israeli and Franco lawyer, international lawyer. He just delivered the file, the ICC complaint on the incitement of genocide
Yes.
by Israeli politicians and soldiers. Do you think that's also a good deterrent for you find it difficult?
No, I think, we always come back to complementarity, right? The ICC, I think, can do better, like, let's say, in this Palestine situation in Palestine. They can issue more arrest warrants, they can increase the charge. Eventually, you cannot prosecute all the individuals who are involved in international crimes. So it falls on state. It falls first on the Israeli state that claims to have an independent judicial system. The ICJ has issued an order to Israel to try the individuals who incite to genocide. That's their job to do. Secondly, it's for all the other courts of the world. I mean, incitement to genocide is part of the Genocide Convention of 1948. I've always said that to the French authorities. I do believe in international justice and universal jurisdiction. It's beautiful that the French court can try a Liberian for a crime committed in Liberia in the 90s. I do believe it participates to our common humanity. But this works at one condition. It works only if France is also prosecuting French Israeli who are committing crimes currently in Gaza. If not, that makes no sense. So I do believe that the future of the crimes committed in Palestine, like in Syria, like in DRC, like everywhere in the world, is also on this feeling that we are part of one community, which is called humanity, and that if you're an Israeli soldier that commit crimes in Gaza, and that the Israeli jurisdiction do not or cannot prosecute you, do not travel. Do not go to Brazil, do not go to South Africa, do not come to France, do not come to Portugal, because you're going to be prosecuted. If we manage to achieve that as a common community, I do believe already that we will have a more deterrent effect than only the ICC, which has very limited power and resources.
So universal jurisdiction is the way.
Universal,
one of big way.
But also personal jurisdiction. Yeah. France, try the French soldiers. That's a very normal, that's a very common agreed principle. America, you have 23,000 Israeli soldiers who have also an American passport. It's your duty to try your soldiers or your citizen what you have not done for the crimes committed in Iraq and Afghanistan. So, before being extremely creative in developing new tools for international justice, let's already work with the tools that exist for decades and decades of criminal law.
Yeah, like Australia that prosecuted now the army.
Exactly.
The soldiers.
If we agree on two key principles, number one, states prosecute their citizens for any crimes, drug traffic, corruption, murders, everybody agrees on that. Two, international crimes, war crimes, crimes against humanity, genocide, are the gravest crimes in the entire humanity. If you agree on these two principles that no one can deny it, why aren't you trying your own citizen when they commit the most gravest crimes, wherever they happen?
Yeah, for sure. It makes total sense, and there is no need for an innovative way to prosecute. The tools are already there. The structure is already there. So to end the podcast, I want to ask you, how do you envision international criminal law landscape following the sanctions on the ICC personnel and in the future, nonetheless?
Well, look, international law, I think, I don't know, you're much younger than me, but even, I had the privilege to grow up in a generation where trying head of state is possible. My parents did not have even this belief. I mean, this was something crazy for them. So already international criminal law is a tremendous progress, but it has been like that. You know, it was created in Nuremberg. It stopped for the entire Cold War. It's starting again in 94. Now we are in a new crisis. But as I said before, I do believe that this crisis was necessary. For me, you know, it's like a virus, not the virus of nationalism. The virus of imperialism is coming back. It's affecting and endangering our democracies. It's affecting the world. It's affecting international criminal law. But international criminal law is here to stay, because yes, Trump is a danger for the ICC, but Trump has a 4-year mandate. The ICC has an indefinite mandate. Yes, Trump and Elon Musk and other leaders, Putin also, are dangerous for the ICC, and the ICC has no soldiers. But the ICC has millions of people who do believe genuinely that yes, when an international crime is committed, people should be prosecuted. So beyond, you know, what state means, beyond, we do believe in this ideal that there should be universal justice and that victims deserve justice. So I don't know, it will sound a bit weird, you know, in these very dark times, but I'm hopeful because I knew that these dark times would come. I knew that these attacks would come at some point, but to a certain extent, we're in a moment of truth, and truth is always good. Was I happy with international justice when he was only targeting Africans? No. Was it better than nothing? Yes. Am I very happy today that we have allies of the Western countries who commit crimes, who finally have to answer justice? Yes, very happy so. And so we knew it would be a difficult times. We'll overcome.
Yeah, I think all this crisis will make 100% international justice much stronger if we pass by the crisis. If we don't, if the international justice doesn't fall. So
it will not fall. You'll be here, Luis. I'll be here. There will be hundred of people who've been tried now, who have been, who've been educated, who've even understood what that means. I mean, the fact that South Africa now is the country. Remember, South Africa wanted to leave the ICC, was actually leading the group of countries to leave the ICC. Now South Africa is respected all over the world. You see South African flags together with Palestinian flags because they do represent a hope of justice. This will not die. They can do anything. They will not come after 8 billion of people who believe that justice is important, whether in Portugal, Brazil, South Africa, or France.
Johann, very inspiring conversation, 100%. Thank you so much for coming. It's been a pleasure, great conversation. I hope my listeners also enjoy. And thanks everybody for listening. Follow us on our social media, in Dubio Pro Justitia networks, YouTube, Spotify, and thank you very much.
Thank you so much, Luis.